And a good Sunday evening, everybody. Welcome to Bethea'S Byte Reloaded, the drama-free true crime destination. I'm Ernest Bethea, the last outlaw. Once again, it's so good to have everybody in the house. And we've got justice on the line this week. We've got the latest in high stakes cases that are either ongoing or about to wrap up with verdict watches, and we've got a lineup to go with that. And we are going to kick things off with the release of a woman who pleaded guilty to second-degree murder for the shooting of her husband's first wife. They call her the Killer Clown. 61-year-old Sheila Keene Warren, released after 18 months. Let's get this show on the road. Let's get everything set here. And we are going to open things up by going right to Court TV and anchor Julia Janae with this report.
We are following the case of a woman who is known as the Killer Clown. She is out of prison. Sheila Keene Warren was released on Saturday. This is nearly 18 months after she pleaded guilty to the charge against her. She's been in custody since she was arrested back in 2017 for the shooting death of her current husband's then wife, Marlene Warren. Keene Warren was allegedly having an affair with the victim's husband when she shot and killed the victim, all this while being dressed as a clown. She pleaded guilty to second-degree murder in Florida shortly before her trial was set to begin. So now we have with us someone who can give us all of the details on what happened. State Attorney for Palm Beach, Florida, where this happened. The prosecutor who was on this case, Dave Ehrenberg, friend of the show, is with us. And Dave, you're always so great at breaking down all of these cases we have here on Court TV, but you are our primary source for this case. And a lot of people may be surprised. They may think, okay, we just saw her not too long ago pleading guilty. How is she out now?
Well, good to be with you, Julia. You know, she's out because when she committed this horrific crime, it was 1990. And back then they had a system where you got a lot of gain time when you're in prison. And because it occurred so long ago, we had to subscribe to the rules of that time. We're forced to, and the Department of Corrections have made the decision to let her out now based on whatever calculation they have. It's a generous calculation according to the rules of 1990, and obviously we're not thrilled with it, but it is the decision of the Department of Corrections in Tallahassee to do so.
Wow, and I want to confirm that she's been there since 2017. So essentially, has she served 7 years of the sentence? And remind us what that full sentence was.
Correct. Well, she's actually been in solitary confinement for 5.5 years. The first 5.5 years of this, she was in the solitary confinement in jail. And that was something her lawyers wanted because they didn't want her talking to other people, apparently. But that's no fun. And so that took a bite out of her. And then after that, she was sentenced to prison as a result of the settlement. And she is now getting out. So she'll have served a little bit over 7 years in incarceration. But mind you, she can't just go home the same person as she was before. She's going home as a convicted, admitted murderer. That is a stain that will never wash away. It's not like she can just go home to her friends and family and say, hey, that was just a nice little vacation. No, quite the opposite. And if I were her friends back in her previous life, I would never want to see a person like this again or let her in my house. I mean, is this the type of person you want to babysit your kids or to babysit your pets? You want nothing to do with her. So it's not like she can just go home and get her old life back. Plus, this was a settlement that the survivor of the victim in this case, Joseph, he agreed to because he knew that the alternative could be that she goes free entirely.
Speaking of her old life, we know she was married to this husband who was at the center of this case. Can you tell us more about that relationship?
We had wondered if she was going to give up her husband. We had suspicions that the husband was involved in it, but we don't have any firm evidence that that is the case. And such we couldn't file charges against him. But someone had to tell her that the victim in this case, Marlene, was at home on that Saturday, and the husband did have an alibi. He was in a car driving to the dog track that day, the horse track, dog track, with others, and they got the call. And he then suggested maybe it was other people who may have done this. Of course, never mentioned it could be his mistress. So we had our suspicions, and we still do, but she never gave him up.
And are they still married? Do we expect that that's part of her returning to her old life in this case? I understand that he was there supporting her, at least at some point during this long, drawn-out push to get to a trial.
Yes, as far as we know, they're still married, and she may go back to her home where she was living before. She had changed her name when she moved away. She changed it to Debbie, so we'll see if Debbie reappears in that same group of friends in the same community. We'll see. I do think that they're going to try to have a normal life again, but you just can't go home again after you've admitted in open court that you murdered another person. And look, there are a lot of telltale signs here, right? A few years after the murder, the two of them got married. The mistress and the husband got married. I know people grieve in different ways, but it was pretty suspicious when you marry not only your mistress, but the person who is the chief suspect in the murder of your wife. And then there was the DNA evidence. And so, look, there's no doubt that she is the murderer in this case. She's a cruel, despicable individual for doing it. The problem is proving the case 33 years after the murder occurred. Fortunately, we're able to do some justice here, but the case aged. I mean, evidence spoiled and memories faded, and individuals who are key witnesses died. And so it made it very difficult, which is what compelled us to have to take this deal.
Well, I think the outcome seems to be justice because it was such a long time since this happened, and when we consider the case almost cold, Dave, can you tell me about the victims, the ones who were there representing Marlene? How do they feel about this release and this new news?
I haven't spoken to Joe. He is the main survivor here. That was Marlene's son. He was there and saw his mother get murdered by this evil clown and chased after the clown. It was key in providing us important information back then. It just was sad that the case wasn't prosecuted for 33 years. And that's why, well, actually it was 27 years when she was arrested. But then it's sad because of COVID and all these delays for another 6 years. So justice delayed is justice denied, but he approved of the plea deal because he knew this was a measure of justice in at least getting a person who thought she got away with it. She had lived her new life. She got everything she wanted out of this until the long arm of the law caught up with her. And he approved of this deal. I have not spoken to him since she was released, but he knew also that it was possible the Department of Corrections would release her because they have to subscribe to the old laws back in the day when it was like a revolving door of criminals getting out of prison. That's why we have these new tough laws, like 85% sentences must now be served. So unfortunately, we're stuck with the laws that were existed at the time in 1990. And I have not spoken to Joseph, but he has handled this really well overall, like a real mensch.
Wow, Dave Ehrenberg, thank you so much for filling in all the details. This is the outcome that you want, despite what feelings there may be about her release so close in time to her plea. When you have a cold case, this is the outcome you want to see, that justice is served. So thank you so much for coming on and breaking that all down for us.
That looks to be one of those cases that you can put your finger on and say, wow, I didn't see this coming. Or this wasn't on my 2024 Justice bingo card. But in the interest of justice, they're saying this could very well be justice served. But I'll let you be the judge of that. Right now, we have a trial going on as we speak. Brandon Janik is charged with the second-degree murder of Josh Gilliland, who was killed by a hit-and-run driver. killed in the crosswalk. Oh, and there is a verdict reached. There is a verdict reached in that. And so, ladies and gentlemen, this is one of many cases like this. This is why I titled this edition "Justice on the Line." That we have a number of verdict watches. We have one. We have one in deliberations as we speak. We'll talk about that in a little bit as well. Right now, I'm going to take you right to the courtroom where the verdict has been reached in California versus Brandon Janik, killed in a crosswalk murder trial.
And now to California for another something else you need to know tonight. Jurors have decided the fate of the defendant in the killed in the crosswalk murder trial. Prosecutors say Brandon Janik ran a red light and killed a 47-year-old named Joshua Gilliland as he was walking across the street. He's charged with second-degree murder, gross vehicular manslaughter, felony hit and run, and felony DUI. Gilliland was on his way to work at Cheers, a bar where he had worked for more than years when he was killed. Witnesses say several people stopped to help the victim, but Brandon Janik did not, and he's now been found guilty on all counts, including murder. He wiped away tears as the verdict was read.
In the Superior Court of the State of California and for the County of San Diego Central Division, the people of the State of California plaintiff versus Brandon A. Janik defendant. Case number SCD 300413. Verdict count 1, second degree murder. We, the jury, in the above entitled cause, find the defendant, Brandon A. Janik, guilty of the crime of second degree murder in violation of Penal Code Section 187A, as charged in count 1 of the information, dated November 7, 2024, signed by juror foreperson number 4.
Janik faces 15 years to life behind bars plus an additional 8 years for insurance fraud charges. He's going to be sentenced next month.
I'm on. Try refreshing. Let me see if I can get this message to you from here. Try refreshing your page. See if that'll help you. Alright, so like I said, that trial will kick off in May of 2025. Oh, there you go. See? Alright. Alright, it's good to have you in the house. Alright, we're gonna move on down the docket. And we have a strange case. According to documents, Joshua Huntsucker is charged with witness intimidation after allegedly trying to poison his daughter with the same drug that killed his wife. Yeah, that is one that still got me scratching my head a little bit. This is out of Gaston County, North Carolina. So it's right near my old neck of the woods. A former paramedic in North Carolina accused of murdering his wife and poisoning his daughter will remain behind bars after being denied bond at a hearing. 40-year-old Joshua Huntsucker is charged with first-degree murder of his wife Stacy Robinson Huntsucker, who died on September 23, 2018. Joshua told people that Stacy died of a heart attack and immediately had her cremated. He also filed a claim for a $250,000 life insurance payout just days after his wife's death, according to court documents. Stacy had been an organ donor, and as a result, a vial of her blood was kept in a file. Investigators tested the blood, citing Joshua's odd behavior, and found that she had been poisoned with tetrahydrozoline, found in eye drops. In a bond motion reviewed by Court TV, prosecutors said that before Stacy's death, Joshua told two former co-workers that if he killed someone, he would do so using Visine or other eye drops. Investigators say Joshua, believing police were closing in on him for his wife's murder, began behaving erratically to shift attention away from himself. On November 26, 2019, days before he arrested, Joshua allegedly set fire to a medical helicopter while he was on board working as a paramedic. The helicopter made an emergency landing. Joshua is facing charges of burning personal property in that incident. Days after he was arrested and charged with his wife's murder, Joshua bonded out of jail on December 24, 2019, Christmas Eve. Prosecutors say on February 4, 2023, Joshua again tried to distract from his case when he staged his own kidnapping and assault. Joshua told police that he had stopped to change a flat tire when he was pistol whipped in the head, zip-tied, and injected with an unknown substance. Joshua told police that his attacker was John Robinson, his late wife's father. Police found no evidence that Robinson attacked Joshua, but rather discovered that Joshua had been stalking and harassing his former in-laws. The harassment included driving by their home, following them, and sending packages to their home. At a July hearing, a judge determined that Joshua had been neglecting both his children, ages 9 and 11, and that he had allegedly abused the 11-year-old. Prosecutors say Joshua poisoned the 11-year-old by putting tetrahydrozoline into her drink. The child, identified as PH in court documents, was taken to the hospital with low blood pressure, low heart rate, extreme exhaustion, and constricted blood vessels. Prosecutors said that in addition to tetrahydrozoline, I don't think I can pronounce that, but I'm going to try. Desmethylphenylvaccine, a drug commonly prescribed for depression and not approved for the use in children, was also found in PH's system. The same drug was allegedly found in Joshua's truck. Court TV has covered a murder involving eye drops before. Jesse Kursurski was convicted of killing her friend Lynn Herman, who died of tetrahydrozoline poisoning. In that case, Kursurski had claimed the victim enjoyed drinking the solution. So let's see what we got. What we got from Amy coming out of this. Let's see. Just popped on. Okay, guy's a total nutcase. I can agree to that. Crazy and stupid. I can agree to that too. I mean, who in their right mind would, one, poison his wife with eye drops, and then two, abuse his their 11-year-old child the same way? Plus, to add a little something extra, give that child something for depression. That's child abuse right there, and it's a crazy case. The guy is a total nutcase. I agree with you, Amy, and we will see just how this case plays out when this trial takes place. Next up on the docket. Oh no, I'm gonna save that for a little bit later. But this one I can drop in right now. We have a verdict in the burned alive murder trial, South Carolina versus Craig Lewis. As you remember, Lewis is accused of beating his wife and setting her on fire, causing injuries that led to her death. So we're going to get ready and go to the courtroom right now, and we are going to get the verdict in this case.
Thank you very much, sir. Thank you. Madam Clerk, can you publish the verdict? Thank you.
In the case, State of South Carolina versus Craig Anthony Lewis, indictment numbers 2019 GS 15 00138, charges arson in the first degree. Indictment 2019 GS 15 00129, the charge is murder. As to the charge of arson first degree, we, the jury, find the defendant, Craig Anthony Lewis, not guilty. As to the charge of murder, we, the jury, find the defendant, Craig Anthony Lewis, not guilty. And this was signed by the foreperson on today's date, November 7, 2024.
Thank you. Would either party like the jury to be polled?
No, Your Honor. No, Your Honor.
All right. Thank you. Members of the jury, thank you very much for your service. Our entire judicial system could not function without people like you who are willing to give up your free time, your time from work and family to come in and make these difficult decisions. I thank you for your attention. I thank you for your hard work. I know it was a difficult decision for all of you to sort through all of that information, all that you heard, all that you looked at, and come up with a verdict. And I appreciate it. If any of you want to discuss any of this with me, you're welcome to give me a call at some point. Can be found in the Beaufort Clerk of Court, through the Beaufort Clerk of Court. You are welcome now to go discuss this case with anyone that you would like. You're not required to, however. If anyone begins to bother you or harass you or anything about your verdict, please contact me through the Colleton County Clerk of Court's office immediately, and we'll have it taken care of. Does anyone have any questions? All right, then. I would thank you all for your verdict. Any objection to releasing this jury?
No, Your Honor. None from the defense.
Thank you all very much.
When we get a case and we prepare for a verdict, and the verdict comes back not guilty on all charges. But here we are. South Carolina man has been acquitted of all charges. He killed his wife by setting her on fire, causing injuries that took her life 10 months later. 47-year-old Craig Anthony Lewis was charged with murder and arson in the death of his wife, Terry Lewis. The jury deliberated for only a couple of hours before returning verdicts of not guilty on both counts. Police said Craig assaulted his wife over 2 days, beginning January 16, 2019. In documents reviewed by Court TV, police said that Craig hit her with, quote, personal weapons and the butt of a firearm, shotgun, breaking the weapon over her hip. Terry was bleeding and had trouble walking after the incident, police said. The next day, on January 17th, police said Craig lit his wife on fire inside their home in an attempt to kill her. The front of Terry's body suffered severe burns, and she succumbed to her injuries 10 months later. Terry's daughter, Leanne Cronky, told Fitz News that her mother began fighting with Craig on January 17 because Terry told him that she was leaving. The argument allegedly turned physical, and Terry said that Craig violently raped her before throwing a rag or a shirt lit on fire at her. Terry said that when she tried to throw the rag away, Craig would throw it back until she caught fire before finally stepping on her hand and crushing it. Despite a criminal history with prior convictions, Craig was granted a $100,000 surety bond with ankle monitoring at a bond hearing and had been free since February 26, 2019. And again, that's according to a report from Fitz News. So once again, Craig Anthony Lewis, not guilty of first-degree arson and not guilty of murdering his wife. So that still remains who did it and why. I guess that question remains to be answered, as the case, I guess, is still open. Next up, Sarah Boone has filed a new motion, well, at least her attorney did, filed a new motion to for a new trial because it's saying prosecutors stepped out of line and the judge ruled improperly. All right, I'll touch on it before we go to the video on this. As Sarah Boone awaits sentencing for murder, her attorney is fighting to get her a new trial by arguing the judge erred in his rulings and prosecutorial misconduct. A jury convicted Boone of second-degree murder for the death of her boyfriend George Torres Jr., who was found zipped up in a suitcase in the couple's apartment after a night of drinking. Boone testified at her trial that she had acted in self-defense and that she suffers from battered spouse syndrome, while prosecutors emphasized that she had left the victim to suffocate after additionally beating the suitcase with a baseball bat. At trial, Boone was represented by a robust defense team led by James Owens. While Torres died in February 2020, Boone's case did not go to trial for 4 years. in part due to delays by a constantly changing defense team. 8 attorneys represented Boone before Judge Michael Cranick ruled that she had forfeited her right to an attorney and had to represent herself. In the motion for a new trial, Owens argued that the ruling violated Boone's Sixth Amendment right to representation. Owens wrote that Boone's behavior did not rise to the level of misconduct required to sustain the ruling, and that Judge Cranick failed to warn her that repeated misbehavior would result in losing her right to an attorney. Let's go to that courtroom right now for coverage in this, for coverage of this.
The jury find the defendant guilty of murder in the second degree as charged in the information. So say we all dated at Orlando, Orange County, Florida on this 25th day of October 2024. The form has been signed by the foreperson.
Welcome back. And before we get you back into the burned alive murder trial in South Carolina, we have an update in the suitcase murder trial of Sarah Boone.
Today, her attorney, James Owens, filed a motion for a new trial. Now, he claims that the court erred in ruling that Boone was not entitled to court-appointed counsel, and the court also erred in denying motions for a continuance. Owens also says the court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in court in the presence of the jury prior to deliberations.
Other claims include these. The court failed to disallow opinion testimony of the state's rebuttal expert after the state failed to disclose that the witness changed her opinion. And finally, the defense alleges misconduct when the state made a second closing argument instead of a rebuttal argument. Now, on October 25th, the jury convicted Boone of second-degree murder in the death of her boyfriend, George Torres. His body was found zipped inside a suitcase back in February of 2020.
Boone used the battered spouse syndrome defense, claiming that she was the victim of constant abuse by Torres. Boone is scheduled to be sentenced on December 2nd, and she faces up to life in prison.
Now to my commentary on this new motion. Now, this is just my opinion, folks. I truly have no skin in the game, but allow me to speak my piece on this. Before Owens, she went through 8 different attorneys, each one with the same task as Owens: to defend Sarah Boone vigorously, in the hopes that she would be found not guilty by a jury of her peers in the death of George Torres. The problem was Sarah Boone wanted each attorney she had, each defense attorney Sarah Boone had, she wanted them to give her attention constantly, despite the fact that those attorneys may have other clients. They can't just zero in on just you because you want it that way. And each time it goes down, yeah. Each time it doesn't go your way, that attorney wants to quit, and another one comes up, and another, 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 until the judge finally said like one of my favorite old school shows growing up, 8 is enough. Since you can't since none of your attorneys are satisfactory to you, what's going to happen now is you're going to have to represent yourself. You'll be a pro se defendant. You'll have to represent yourself since you're the smartest person in the room. Then here comes your Superman, James Owens, to rescue your case, to salvage your case, Sarah Boone. And even still, your case still ends up with a guilty verdict. So be honest with yourself. How well did that work out for you? And be honest with yourself. How well will this motion work out for you? That's my opinion. But I want everybody to know this: that Owens noted in the motion that despite his filing notice of appearance just 45 days before the trial was scheduled to begin, Judge Craven refused to grant any continuances, which is a smart move, in my opinion. Quote, despite his best attempts to prepare for trial, it was impossible to adequately prepare for unseen issues arising during trial. A prime example of this would be viewing hundreds of pages of text from Miss Boone's seized cell phone, viewing all records of prior contact of Ms. Boone and the alleged victim with law enforcement, including admissible hearsay by the alleged victim to law enforcement regarding Ms. Boone being the aggressor at times. Counsel, for all purposes, closed his law practice down to prepare for the trial, but due to the short time frame, even with the assistance of other attorneys, was simply logistically unable to be as prepared for trial as he would have liked to be, and as Ms. Boone was entitled to. End quote. All I can say to that is, that's the fault of your client. And that's exactly where I'm gonna leave that at. That's the fault of your client. Next up, the state's highest court is hearing arguments in Karen Reed's case. Here's another case where I have no skin in the game, but I've got a great bit to go on. But first, thank you, sweetheart. All right, ladies and gentlemen, I hope you've seen this. This is what the lady outlaw does for the last outlaw. This is some great coffee. Keeps me alert, keeps me awake, and I can keep going. I can go on this all night. Oh, Juju Bones in the house. How you doing? Good to have you here. All right. What I'm gonna do, I'm about to mute right now so I can take a few sips of this coffee, and I'm gonna give you some of this video from the hearing at the State Supreme Court of Massachusetts regarding Karen Reed.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston, within and for the Commonwealth, draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now in session. Please be seated.
Okay, good morning. Madam Clerk.
SJC 13663, Commonwealth versus Karen Reed.
Attorney Weinberg.
Good morning, Chief Justice, Associate Justices Martin Weinberg on behalf of the appellant Karen Reed. Today's appeal goes to the core issues regarding double jeopardy protection that safeguard defendants, in this case Ms. Reed, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent, and we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we contest uncontradicted showing that the prior jury reached a unanimous decision to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first...
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
I don't have a basis to...
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof that a 5th juror contacted the defense. A juror who could have been one of the 5 and could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
What I am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2, and that this court's jurisprudence strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court, at which we contend the probability, if not the certainty, that that voir dire would result in proof that there was a final and binding...
Mr. Weinberg, you jump all the way to acquittal, correct?
Yes.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
In the face of the juvenile case, in the face of Taylor, how is this an acquittal?
It's less a matter of labels. I could call it, Judge, a unanimous decision.
Well, you said Taylor, which is the case in Quincy where the judge basically, there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error.
Yes.
That case is an opposite to what this situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declaration.
Well, that's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than many cases where this court has remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think it's an extension of prior precedents. Fiddler talks about not establishing inflexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was...
Doesn't Fiddler caution to not inquire into the, not to intrude into the sanctity of the deliberative process as well?
It does.
Absent this extraneous influence. But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
I would argue that it has to do with the results of those deliberations and that a carefully set of questions preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result.
I said that I would yes, that the video is about an hour long. I said I wouldn't play all of it, and I haven't. But here's the way this breaks down. Now, it's the latest chapter in the Karen Reed saga moves to the state's highest court, where attorneys are hoping to convince judges that several charges related to the death of her Boston police officer boyfriend should be dropped. Karen Reed is accused of ramming into John O'Keefe with her SUV and leaving him to die in a snowstorm on January 2022. Reed's attorneys argue that she is being framed and that other law enforcement officers are responsible for O'Keefe's death. The judge declared a mistrial in June after finding jurors couldn't reach a unanimous verdict. A retrial on the same charges is set to begin in January, though both sides asked Monday for it to be delayed, last Monday I should say, that it should be delayed until April 1st. The defense reiterated arguments made in briefs to the Massachusetts Supreme Judicial Court that trying Reed again on charges of second-degree murder and leaving the scene would be unconstitutional double jeopardy. Defense attorneys said 5 jurors came forward after her mistrial to say that they were deadlocked only on a manslaughter count and had agreed that she wasn't guilty on the others, but they didn't tell the judge. I'm gonna stop reading right there, and I'm gonna risk sounding like a broken record, but please hear me out once again. Before that judge even were to even make the announcement that the jury has reached a mistrial, you know what? Let me take this a step further. I'm gonna put myself on the judge's bench. The jury comes back to me and says, "Your Honor, we are hopelessly deadlocked." The first thing I would ask, because I know the attorneys would want to know. And personally, I would want to know, where did they agree and where did they disagree? So the first thing I would ask the attorneys, both prosecution and defense, would you like to poll the jury? I mean, it's that easy when the verdicts are already. If it was a simple guilty or not guilty, why couldn't this judge do the same thing on declaring a hung jury or even a mistrial? If it's voluntary manslaughter where they disagree on, we would all know. We would all know, because in normal jurisdictions, it takes 12 for a unanimous verdict. Anything less hangs a jury. So, where is this jury hung? Was it on the manslaughter charges, or was it the murder? That's where you poll the jury. That's where you find out for sure where this jury stands. Where are they in agreement? Where are they in disagreement? And once that's settled, then you can make that announcement that this is a mistrial. And once that's said and done, let's see, Juju Bones. I haven't followed Karen Reed very closely. What does everyone think? I don't know yet. I thought it was going to be an open and shut case, But then there's so much testimony, so much drama, so much this, so much that, and the hung jury didn't do any favors. Which is why I'm saying what I'm saying now. Both sides should have polled that jury on those charges. Doing that would have made it crystal clear as to why this is a hung jury. And if they couldn't get together on that, then the judge would have been right then to declare a mistrial. Set it up all over again, but only on the one charge that they were hopelessly deadlocked on. If it was the manslaughter, do a retrial on the manslaughter charge. If the murder, let her go to trial again on the murder charge. That way, there is no wiggle room. There is no claim of double jeopardy. This hearing would have never mattered. They would go to trial. They would make sure, okay, this is it. We're gonna get this. We're gonna get all the evidence right. We're gonna get all the testimony right. We're gonna put it all together in one shot. And when it's all said and done, we're gonna get a definitive verdict out of it. Let's see, Amy Cruz says, people who follow it say the evidence doesn't support her SUV hitting him. In a way, I kind of agree with that, but like I said, it was such a mess. It was such a mess throughout the entire trial. And on top of it, like I said, they didn't poll that jury just to find out where that jury stood. Now you have 5 different jurors popping up saying, "Oh, we didn't vote this way. We didn't agree on this charge." Da 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 da. Juju Bones says, I know it's a very polarizing case like Delphi. Law enforcement has to make sure they are doing solid investigations. It is so hard to go to trial on weak evidence. Absolutely. Absolutely. And then on top of that, she adds that there are members of law enforcement that is the other possible suspect. And you're right about that too. You're right about that too. It's like Boys and Girl Scouts, ladies and gentlemen. Boys and Girl Scouts, whatever they're dealing with, they always come prepared. They always come prepared. Let's see, Juju Bones. Gotta look into this one more now. You got me interested. Hey, do the research. Do all the research you can. Get as much knowledge in this case as you want to. Just remember that this in fact before January or April, depending on when they actually have this retrial. There's a mistrial declared because a jury could not agree on a solid verdict, whether it be manslaughter or murder. Let's see. Juju Bones again. Typically, they do in most trials. I wonder why they didn't see. Juju Bones is right there. Typically, they do poll the jury in most trials. Yes, but normally they poll the jury in most trials right after a guilty or not guilty verdict, especially when it's unanimous. like I said, if it were up to me, I would have done this myself. I would have done it despite the attorneys. I would have made the ruling that I would have pulled them right there and then, and ask each question on the charge of juror number one. What was your verdict? Is that your verdict then? And is this your verdict now? Those three questions I would have asked each one. And as as they were telling me, and as they were telling me what the verdict was, I would have had it marked down. I would have tallied it myself. Let's see. Did the defense request one? No, ma'am. No, they didn't. If they had, we wouldn't be talking about this like this right now. Like I said, I've got no skin in the game. I want to see justice served, and the only way that can happen is had they did it right, is if they had polled the jury right before the judge even declared the mistrial. Now both the prosecution and Karen Reed's defense have got to go through all the headaches to either get the charges that allegedly jurors claimed they acquitted her on cleared, or go through this retrial with everything on the table. And like I said, that is a straight up and down headache. I'll keep you guys informed as this goes along. All right, we've got a brand new case out now, out of the great state of Hawaii. Now, I want you to pay attention to this. Dixie Denise Villa is charged with manslaughter for the diphenhydramine overdose death of 7-month-old Abigail Lobish. Diphenhydramine overdose death. I'll give you the details and then I'm going to take you right to Court TV's Matt Johnson and Julia Janae. A Hawaii woman is accused in the death of 7-month-old girl standing trial 5 years later. Dixie Denise Villa, as you can see right here, is charged with manslaughter for the overdose death of Abigail Lobish. According to court documents, an autopsy revealed Lobish had a fatal amount of diphenhydramine, commonly sold as Benadryl, in her system. The child was under Villa's care overnight when she died on February 24, 2019. Villa was allegedly operating an unlicensed daycare at her home at Alamanu Military Reservation. Lobish's bloodstream had a level of 2,400 nanograms per milliliter, which is nearly double the amount that has been proven fatal in infants, according to Stars and Stripes. Outside of the criminal case, Lobish's parents filed a lawsuit naming 10 defendants, including the United States. The lawsuit claims the defendants' negligence led to Lobish's death and that military police had shut the daycare down multiple times before the child died, mostly based on calls placed by neighbors. The girl's mother, Anna Lobish, told Military Times she wasn't made aware of prior allegations against Villa until the day her daughter died. Villa has been out on bail after posting a $200,000 bond, according to Hawaii News Now. So now, I'm gonna go ahead and take you right to Court TV. Matt Johnson, Julia Janae is gonna cover this one a little bit further. Juju Bones says she should be charged with more than manslaughter. Is that more eye drop? No, this is no. That's not eye drops. Thank God. Yes, it's sold as Benadryl. Amy says I can't stand when children are drugged to get them to go to sleep. And then on top of it, she says Lori Vallow pulled that crap. That she did. That she did. All right, let me get out of the shot now. Let me take you to Matt Johnson and Julia Janae.
Prosecutors say Dixie, Denise, and Via gave baby Abigail Lobish Benadryl to make her go to sleep, and it was a fatal dose. The baby never woke up, and the defense claims that Via wasn't the one who gave the baby any medicine.
Such a sad case, and the judge, we want to remind you, has restrictions on us airing this trial live. So will be the key testimony today from yesterday. We just heard from the redirect. We just heard the redirect from baby Abby's mother and a little bit. Now it's time for the recross. Let's get you back to court.
You're talking to Clay about the fact that you're concerned you took Tylenol PM and stuff like that. Yes?
Objection, form of the question, argumentative.
Overrule if you understand the question, couldn't answer. If not, ask her to rephrase the question.
Sorry, if you could rephrase that.
Sure. You're testifying to this jury that you mixed up BM, meaning breast milk, with the word formula. It's your testimony, yes?
Yes.
Miss Lobish, have you read this direct message?
I have, yes.
So you understand its contents?
I do.
You know the person you're speaking to, Kale, who's in this room today, right?
Yes.
You're talking about the concern that you have because you were taking Tylenol PM and stuff like that. And you were telling her you were concerned about it being in your breast milk. Correct?
Yeah.
She even tells you, go and delete the breastfeeding picture that you posted. Go delete it. Right?
A lot of people were.
No. Is that what she said?
Objection, you're saying.
Overrule.
Yes.
You respond to her. You guys are talking about keeping the story straight about formula versus breast milk, correct?
Sorry, can I take a break?
Let's take a break. Ladies and gentlemen, we'll take a short recess here. Please do not discuss the case among yourselves.
And we're going to ask the court to order the witness not to talk to anyone about her testimony.
Do not talk.
I won't.
Ms. Prosecutor, just make sure that doesn't happen. Right, man? Recess. Mr. Turley?
Not that she would anyway, but they were pointing at someone in the gallery, which she tried to have this witness identify earlier during her testimony, and now we know why.
All respect to this mother, of course, for losing her child, but that's not a good look when you are being crossed about trying to cover things up after the
fact.
What
it appears as a cover-up.
And then she says, I need to take a break instead of facing the question and answering them. it doesn't look good in front of a jury.
Let's bring in our guest joining us this hour, criminal defense attorney and former prosecutor, attorney Matthew Mangino. Matthew, let's talk about these text messages, keeping the story straight, as she's mentioned on Recross, and then deleting pictures. And she was concerned about Tylenol PM in the breast milk. What's your take on this?
Well, I think, as Julia said, this is not a good look for this witness on cross-examination. Clearly she tried to say that there was some mistake in whether she was talking about formula or breast milk, but clearly through this questioning, we know that it's breast milk because the issue was the Tylenol PM in the breast milk, and that she thought, and the person she was texting thought that could come back to harm her, and there's talk of deleting pictures and things like that. So between her testimony about the breast milk and the formula and the testimony with regard to why she actually needed a babysitter that weekend, clearly indicate that she's not being as forthcoming as she should in terms of a witness.
Yeah, it doesn't mean that she's necessarily involved, but it can attack her credibility. To your point, Matthew, that sidebar is broken up. Let's go back in and listen to the continued testimony once Anna Lobush has now come back to the stand.
Okay, Ms. Lobush. Your friend Colette is telling you to stick to the story of formula, correct?
That's what it says here.
You express your concern that they could test the breast milk that you donated, yes?
Yes.
And that they'll try to use it against you, correct?
Yes.
Colette even encourages you and says, make sure the DA, meaning the district attorney, is sticking with the story, correct?
Hold on a minute. Excuse me there.
Oh, Judge, we already talked about it, media.
I asked your bailiff, I'm sorry.
Okay. All right.
So your friend Colette encourages you to make sure the DA, the district attorney, is sticking with the story, correct?
Yes.
So, to be clear, BM in your message means breast milk, yes?
Yes.
Thank you. Nothing further.
And you redirect.
No.
Thank you. All right, Ms. Lopez, thank you. You're done. Just leave everything there.
Kind of a clunky way to end the testimony of the victim mother there. Let's bring back in Matthew Mangino, former district attorney Matthew Mangino, because I have a question about this state witness. Do you think she should have been better prepared for these landmines that could have potentially come out? Should they have gotten ahead of it better and direct?
Well, you would think that you'd want to be prepared to have your witness certainly testify truthfully. So in order to do that, you go back and you look at these messages and you make sure that they're in the proper context and that she is conveying to the court essentially what she conveyed in these texts. And that was dramatic, that last question, because she acknowledged that BM means breast milk when she testified earlier that she was confused about, she used the wrong word, formula or breast milk. So clearly, it shows that she was deceptive in her testimony.
Really solidifies why this went to trial and the defense in this case.
That took a turn. We have a defendant on trial for this, and the victim's mother was on recross examination, and she's all hung up on that question about the breast milk and all. Let me dip right in the chat real quick. Wait, let's see, Amy. Speaking of prepared, I'm unhappy that the Torres family wasn't warned about the awful video being shown in open court. They're talking about Sarah Boone's case. Hey, it's that I agree they should have been better prepared than that. Juju Bones, back to this case. Not sure what the law would be, but surely she has broken one. It's possible. It's possible. That's the reason why I said earlier when she was on recross, OMG, could it be we have the wrong defendant in this case? We'll have to wait and see because like I said, they're not airing this trial live, but they will pick up on key testimony as the case rolls on. Stick to the story of formula. That's the key phrase. Could be pivotal to the way this case ends for the defendant if she's found guilty or not. Next up, we're gonna go to a sentencing hearing. Heavenly Faith Garfield was sentenced for the death of Brooklyn Barrett, who was killed in what prosecutors called a suicide pact. Now, but before we go to that video, let me give you a bit of a recap of what had happened. Utah woman was sentenced to 1 to 15 years in prison after her friend was killed in what prosecutors call a suicide pact. In September, Heavenly Faith Garfield pleaded guilty to manslaughter in the April death of 21-year-old Brooklyn Barrett. Garfield was initially charged with murder and discharge of a firearm, but took a plea deal in her case. She was facing up to 15 years in prison. According to court documents, police responded to a home at approximately 3:26 p.m. after Garfield's father called 911 to report his daughter had killed her friend. An affidavit states that he told dispatchers the victim, identified in court as Brooklyn Barrett, had been shot at 10:45 a.m. that same day. So we're gonna go to that sentencing right now, and in a lot of these sentencings, whether some relative or other of the victim actually offers forgiveness. That's the surprising thing in this one, and here it's the mother forgiving Heavenly Faith Garfield. Let's go to that sentencing right now.
We are continuing our coverage in the sentencing hearing in the Friends Suicide Pact case in Utah. Earlier, we heard the emotional statements from the family of the defendant, Heavenly Faith Garfield.
Well, now the mother of the victim, Brooklyn Barrett, is speaking, and at several moments, she addresses Garfield.
Good morning, Your Honor. I wanted to let you know about my beautiful daughter, Brooklyn. But I'm going to let the video that was made for her funeral show the love and light that she brought to this world. Her life was a beautiful tragedy. Brooklyn loved the natural beauty of the world and loved to photograph and draw it to find peace. Her smile and laughter were infectious, and she made people made people feel seen and loved, even in the thick of her darkness. In her short life, she had to endure so much pain and heartache. She was adopted twice and lost her adopted mom at 10, leaving a deep scar and hole in her heart that would not heal. Your Honor, we spent a lot of time, a lot of money on therapy and inpatient hospitalizations trying to get her the help that she needed. And I know it sounds bad, but I found comfort in knowing that she was too afraid to take her own life. I found peace and comfort knowing that. wish she was still here so I could have given her that opportunity to get more help and support that she needed. Your Honor, let me take you to April 30th. It seemed like any other day. I received a text saying, "I love you, Mom," from Brooke, and I was still on cloud 9 from seeing Brooke and Faith the day before at my work, looking happy and in good spirits. At 9 p.m., my whole world changed. 2 sheriffs came to my house to inform me that my daughter was dead and it was being ruled a homicide. That night, I had no idea what had happened. I had to watch my children grieve the loss of their sister, and I was grieving the loss of my daughter. The next morning, I see on the news, and it tells me that Faith, my daughter's best friend, had shot her in a suicide pact that people knew about and nobody decided to tell me. The one person that could have gotten her help and both of them help. Due to Faith's actions, mine and my family's lives are forever changed. I'm dreading all the holidays coming up and the emptiness that we will fill from this year forth. I'm glad Faith is still here to be with her family and will still be able to celebrate. But I find sadness knowing I don't get that. My baby is gone. I forgive you. I forgive you. I forgive you for your actions. Because if the roles were reversed and my daughter was sitting where you are now, I would want for her to get help. And that is all I want from you. I am extremely saddened by your choices and the consequences you are facing for them. But I am very glad that you changed your mind. And that you stayed on this earth. Please heal yourself, Faith, and get all the help that you can so you can come out of this a changed person. And I was going to ask for a hug, but I was told it wasn't appropriate. Thank you.
Thank you very much.
Wow. That's all I can get out of my mouth. Wow. The article goes on to say that responding officers noted Barrett had an obvious gunshot wound to the head and her body was covered with a blanket and there were flowers laid on the bed. During the investigation, authorities provided text messages between a male friend and Barrett in which she stated she intended to commit suicide with her friend. Garfield and Barrett had allegedly been planning to take their own lives for multiple weeks. At the sentencing, as you just heard, Garfield's family and a social worker pleaded to Utah County Judge Derek Pullian to provide mental health treatment for Garfield. Through tears, Northrop Garfield III described a friendship between his daughter and Barrett. When describing the alleged suicide pact, Northrop said, "These girls cared deeply for each other and sought peace in death." Garfield's lawyer Ryan Taylor said Garfield was sexually abused as a child, causing depression and anxiety that led to the suicide pact. He argued that not every manslaughter case deserves prison and urged the judge to consider probation so Garfield can enter treatment. "What Faith needs is what Brooklyn needed," Taylor said, prompting a cry from the victim's mother in the gallery. And as you just heard, Barrett's mother described her daughter's life as a beautiful tragedy, detailed the family's heartache since her death. At the end of the statement, she addressed Garfield saying, "Faith, I forgive you. I forgive your actions because if the roles were reversed and my daughter was sitting here where you are now. I would want for her to get help. I am extremely saddened by your choices and the consequences you are facing for them. But I am very glad you changed your mind and that you stayed on this earth. Please heal yourself, Faith, so you can get all the help that you can and come out of this a changed person. Give me 1 second here. What a woman indeed. That took a lot of strength to as emotional as that situation is during that sentencing. I tip my hat to her. And Amy said in a comment that this case was off the charts, and I agree. It is off the charts, but I'll say this much. As much as I am totally against it, because I've been there personally, and thank God I'm still here. There are people who are bullied, abused, etc., etc., and the only thing they want to do is to have it stopped. And if no one else is willing to do it, the first thing they think of is ending their own life. They just want the pain to stop. They want the hurt to stop. They just want it all to end. And they decide they want to take the route of using a permanent solution to a temporary problem. It hurts. It's sad, but it happens almost on a daily basis. I honestly hope that that Heavenly Faith Garfield, despite the sentencing, despite the guilty plea, I hope she gets the help she needs. I honestly hope that her life turns around for the better. Because in my honest opinion, that's the only way to honor her friend, Brooklyn Barrett. And for everybody watching, if you are someone you know is in crisis, you need help, and you're thinking of, if you're thinking of ending it all, please, please, please talk to somebody. Whether it's a friend, a parent, a loved one, talk to somebody that you can count on.
Hello.
If that fails, you're asked to call or text the 988 Suicide and Crisis Lifeline. I just mentioned the number. It's 988. There is somebody available 24 hours a day, 7 days a week, in well over 150 languages. Somebody is there to help you. Somebody is there to talk you down. Somebody is there to let you know you have a lot to live for. And that's not just coming from the Suicide Crisis Lifeline. Those last words are coming straight from the last Outlaw. Call or text 988 and get help. Okay, next up. Next up on the docket. Let's see. Who mentioned Lori Vallow a little bit earlier? Who mentioned Lori Vallow? Amy! Amy, since you mentioned Lori Vallow a little while ago, I got something for you. A Lori Vallow update. Nah, that'll be only a 30-second clip, so I can go ahead and go through this. Convicted killer Lori Vallow is now represented by new attorneys whose first order of business is working to stop the court from conducting a competency evaluation on their client. Vallow is awaiting trial in Arizona on charges of murdering her fourth husband, Charles Vallow, and attempting to murder her niece's ex-husband, Brandon Boudreaux. Vallow was convicted and sentenced to life in prison in Idaho for the murders of her two youngest children, J.J. Vallow and Tylee Ryan, and her fifth husband's first wife, Tammy Daybell. Her fifth husband, Chad Daybell, was sentenced to death on similar charges. Last month, a judge granted a request from Vallow's previous attorneys to conduct a competency evaluation on their client. Days after the ruling, Vallow moved to fire her attorneys. The filing, dated October 25th, asked Vallow to be allowed to represent herself. The judge deferred ruling on her request until after the doctors evaluated her. The court appointed a new attorney to represent Vallow, who has now filed a motion to withdraw the order for a competency evaluation. Prosecutors have opposed the withdrawal, arguing it would be inappropriate to do so since the court has, quote, already found a reasonable basis, end quote, for the evaluation. However, the prosecution said it does not oppose suspending the evaluation until Vallow's new attorneys can get caught up with the case and discovery. Vallow's trial, which was initially scheduled for February 2025, has been delayed indefinitely pending the results of the evaluation. So the only thing I'm glad of is that Lori Vallow has a new attorney. She fires her old attorneys and wanted to represent herself initially, and I'm thinking, I almost asked the question if she had lost her mind. Then I remember which defendant I'm dealing with here. But had she gone through with it, let me remind everybody within earshot of my voice, a defendant's track record in representing themselves in a murder case is and forever. The last murder defendant who tried to represent himself on a murder charge was back in 2022. Does the name Daryl Brooks ring any bells? It does with me, and I've done the research on this one. I almost did a Bethea'S Byte Reloaded throwback on this case, but then I thought better of it because of the chaos that came with it. Daryl Brooks decided he was going to represent himself in that case. He was eventually found guilty of a whopping 6 counts of murder in the hit and run death at the Waukesha Christmas Parade in Wisconsin. He was also found guilty of the injuries to 61 others in that parade. The sentence: 6 consecutive life sentences plus another 756.5 years in prison. So bottom line, that last outlaw, when is he getting out? Never. He is never getting out. He will never see the light of day again. No, I take that back. The only way he'll see the light of day is if and when they let him out into the prison yard for recreation. So Lori Vallow at one point, boy, thank God she's got new attorneys, because she was going to represent herself. She would be absolutely insane to do so. The record's not good. Excuse me. The record is not good, and it would come right back the same way. Only thing is, this time she would be found guilty in 2 states of murder. So there's my opinion at that. As far as the case goes itself, we'll just have to wait until February of next year to see which direction this thing goes. Next up, we got the verdict now. In Massachusetts versus Quentin Nixon. Not only do we have the verdict, but we may have a sentencing as well. Now, this is what I was talking about before. Oh my God. It's one thing when a murder defendant wants to represent themselves in court. Now, of course, I told you the record is Owen forever. But you really want to give yourself a double whammy? Outlaw, what is the double whammy? You want to represent yourself in court on a murder charge, and instead of having a jury of at least 6, maximum of 12, deciding your fate, you leave your fate in the hands of the judge in that case. Are you serious? Well, this guy was Quentin Nixon, put his fate in the hands of the judge, and he decided to represent himself. So we're going to go to the courtroom right now for the verdict in Nixon's trial.
We have breaking news out of Ohio. The verdict in the medical assistant murder trial for Quentin Nixon has come in.
This is a bench trial, so the judge is on the bench. Let's go back. Let's go into the courtroom in Ohio and see what she has decided about the defendant's fate.
There will be no outbursts of any kind, and if there are, you will be asked to leave the court and not return until this court is done with its business. Thank you. Let me start by saying, Mr. Nixon, I'm going to commend you for your behavior throughout the trial. You were very respectful of the process and the court. That being said, I do believe you did a great and grave disservice to yourself by representing yourself. There are many nuances and trial strategies that a seasoned attorney such as Mr. Perry would have been able to employ throughout this trial. That being said, having decided to represent yourself and waive your right to the jury trial, the responsibility falls on me to render verdicts in these cases. In the case involving the death of Tony Westover, in count 1, you are charged with murder in that the state must prove that you purposely caused the death of Tony Marie Westover with a firearm specification attached. Purpose to cause the death of Tony Marie Westover is an essential element of the crime of murder. A person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to cause the death of Tony Marie Westover. Purpose is a decision of the mind. To do an act with a conscious intent to produce a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all other facts and circumstances and evidence. The defendant is allowed to use deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using deadly force, did not act in self-defense. To prove that the defendant, when using deadly force, did not act in self-defense, the state must prove beyond a reasonable doubt at least one of the following. The defendant was at fault in creating the situation, giving rise to the shooting or attempted shooting of Tony Marie Westover, or the defendant did not have reasonable grounds to believe that he was in imminent danger or death or of great bodily harm, or the defendant did not have an honest belief, even if mistaken, that he was in imminent danger of death or great bodily harm, or the defendant used unreasonable force. Unreasonable force is a person is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger. If the defendant used more force than reasonably necessary, and if the force used is so greatly disproportionate to the apparent danger, then the defense of self-defense is not available. Greatly disproportionate. In deciding whether the force used was greatly disproportionate to the apparent danger, I must consider whether the force used shows revenge or a criminal purpose. In count 2 of and I will add that the defendant has alleged self-defense in all 3 counts, counts 1, 2, and 3, in the indictment. In count 2, the defendant must have caused the death of Tony Marie Westover as the proximate result of committing or attempting to commit felonious assault, also with a firearm specification. The state must prove the elements of felonious assault as to the murder contained in count 2 of the indictment, as well as all of the elements of felonious assault. Felonious assault, the defendant must have knowingly caused or attempt to cause serious physical harm to Tony Marie Westover by means of a deadly weapon, to wit, a firearm. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Knowingly means that a person is aware of the existence of facts, that his acts will probably cause a certain result or be of a certain nature. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. In addressing whether your actions were in self-defense, I find that the state, must find, or the state must prove that there was serious physical harm, which is any physical harm that carries a substantial risk of death. In count 5, because count 4 was dismissed prior to the trial beginning, the defendant must have knowing that an official proceeding or investigation was in process or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence. For each of the charges contained in counts 1 through 3, there are also attendant firearm specifications. The state must prove beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing those offenses and displayed the firearm, brandished the firearm, indicated that he possessed the firearm, or used it to facilitate the offense. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm that is inoperable, but that can readily be rendered operable. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosion or combustible propellant, I may rely on circumstantial evidence, including but not limited to the representations and actions of the defendant while exercising control over the firearm. As to the charge of improper handling of a firearm in a motor vehicle, in case 2206-2276, the defendant must have knowingly transported or had a loaded firearm in a motor vehicle in such a manner that it was accessible to the operator or any passenger without leaving the vehicle, and the accompanying forfeiture specification of the Riley Defense, Inc., RAK 47, serial number B11765. I've carefully considered all of the evidence and the exhibits admitted during trial. I've weighed the credibility of the testimony of all the witnesses, including the testimony of the defendant. It is my province to believe all, none, or some of the testimony of each witness, as well as the physical evidence that has been presented and the exhibits admitted during trial. I have considered the physical evidence and whether it corroborates the testimony of each witness in deciding which, if any, of their testimony I choose to believe. I find there is no credible evidence that Ms. Westover threatened or even tried to harm the defendant. There was credible evidence that the defendant had hold of Ms. Westover either by as to her upper torso, whether by her hair, neck, or shoulder. Ms. Westover was shot 3 times, and the most serious injury which caused her death was a gunshot wound to the back of her neck that was approximately 8 to 10 inches away and included evidence of stippling near the entrance wound, and the trajectory of that propellant was from back to front, right to left with a downward angle. While the defendant's testimony at times was believable, and there were portions of his testimony that he seemed genuinely convinced of the testimony he was presenting, I find a majority of that testimony was completely self-serving, illogical, and completely uncorroborated by the physical evidence and exhibits admitted during trial. In reviewing Exhibit G of the defense's exhibits, there was no credible evidence that you were injured or that your clothes were torn by Mr. Cruz, the machete-wielding aggressor. While you fled the scene, both Adam Wright and Brian Fielders had already both fled, and you still possessed the firearm. Furthermore, once you dropped from the porch, you leisurely strolled away with no signs of panic or fear that you testified you were feeling during the trial. Your statements to detectives the night you were arrested contained various inconsistencies, not to mention were completely inconsistent with your testimony during this trial. Lastly, your actions in fleeing that night with Miss Westover's purse and the firearm, and changing your appearance and hiding out in your cousin's house for over a month shows a consciousness of guilt. This court is left to weave together the offensive events of July 25th, 2022 from all the testimony, the physical evidence, and the exhibits admitted during trial. Based on everything presented at this trial, the more logical sequence of events is that for whatever reason, including being high on methamphetamine, not having slept for days due to that methamphetamine use, and the paranoia that comes with the use of methamphetamines, you shot and killed Tony Westover. And after shooting her, you were attacked by Brian Fielder, and when you had him down on the floor, he bit you while trying to get the gun away from you and from your grasp. According to Ashley Bratton, who testified 2 times, and including yesterday, Adam Wright was on his way out of the back bedroom with a firearm and returned, and upon finding you on top of Brian Fielder, hit you with the firearm and then fled. Everyone fled through that back bedroom because Tony Westover was left dead, hanging over the side of that couch, and was blocking the front door. Therefore, I'm left with only one conclusion. The state of Ohio has proved beyond a reasonable doubt that you committed the crime of improper handling of a firearm in a motor vehicle on June 5th, 2022. And furthermore, by clear and convincing evidence, I'm ordering forfeiture of the Riley Defense, Inc., RAK 47. As to all the charges in the indictment in case 2209-3102, I have considered each count uninfluenced by my verdict as to any other count. And I find that the state of Ohio has proved beyond a reasonable doubt that you did not act in self-defense on July 25th, 2022, and that you were at fault in creating the situation, giving rise to the shooting, or attempting to shoot Tony Marie Westover, and or that you used unreasonable force against Tony Westover. Therefore, I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 1, and the 3-year firearm specification 1 to count 1. I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 2, as well as the firearm specification 1 to count 2. I find you guilty beyond a reasonable doubt of felonious assault, a felony of the 2nd degree, as contained in count 3 of the indictment, and the firearm specification 1 to count 3. And lastly, I find you guilty beyond a reasonable doubt of tampering with evidence as a felony of the 3rd degree, as contained in count 5. The court having rendered its verdict, I am prepared to proceed to sentencing at this time, if both parties are prepared also. Before hearing from the parties, I do find pursuant to Ohio Revised Code 294125, State versus Johnson and State v. Ruff, that counts 1, 2, and 3 for merge for purposes of sentencing. I find that the defendant's conduct is of similar import and was committed with the same animus. Pursuant to Ohio Revised Code 292914B1G, if an offender is convicted of or pleads guilty to 2 or more felonies, if 1 or more of those felonies are aggravated murder, murder, attempted aggravated murder, attempted murder, aggravated robbery, felonious assault, or rape, and if the offender is convicted of or pleads guilty to a specification of the type described under Division B1A of this section, in connection with 2 or more felonies, the sentencing court shall impose on the offender the prison term specified under Division B1A of this section for each of the 2 most serious specifications of which the offender is convicted or to which the offender pleads guilty, and in its discretion also may impose on the offender the prison term specified under that division for any or all of the remaining specifications. Therefore, I find that specifications to count 1, 2, and 3 do not merge pursuant to 292914B1G. Mr. Perry, would you like to talk to Mr. Nixon about a PSI, or is he prepared to waive that right?
I would, Judge, in just a second.
Sure.
Well, guilty on all counts. Guilty on all counts. And then on top of that, before she even passed sentence, the Honorable Christine Croce told Nixon that she believed he had done a, quote, great and grave disservice to himself by choosing to be pro se and represent himself at trial. He had elected to proceed to trial without an attorney or a jury. He was immediately sentenced following the verdict. He addressed the court saying, "I'm not a monster. It didn't happen the way they said it happened." Judge Croce called Nixon's testimony illogical and sentenced him to 21 years to life in prison. Now, Juju Bones agreed with me earlier when she said it's never a good idea to represent yourself. I jumped on top of that and said it's especially not a good idea to represent yourself and put your fate in the hands of the judge in the case. Hashtag double whammy. I will stand by that until I can no longer do this. So Quentin Nixon, I guess he might be the only one I'm doing last rites for. So I'm putting Quentin Nixon's name on my list. All right. Next up, Pastor John Paul Miller is released from jail after an arrest for assault. Let's check that out. Okay. Days after federal agents were seen raiding his home, Pastor John Paul Miller was arrested on an unrelated charge of assault and battery. Miller, who was thrust in the public spotlight following the suicide of his estranged wife, Micah Miller, was arrested on November 6 on a single charge of third-degree assault and battery. That's according to records reviewed by Court TV. John Paul left jail after posting a $776 bond. In a statement, the Myrtle Beach Police Department said it was called to the area of John Paul's church on November 6 for a report of a disturbance. No further details were released beyond the police saying that situation is under control, but you will continue to see a police presence in the area. Video obtained by Court TV shows a confrontation at the property involving John Paul and someone participating in the demonstration. After making a motion at the woman that appeared to anger her, the demonstrator said John Paul put his hands on her. Protesters have been a common sight outside of John Paul's home and church since his wife's death. Micah filed for separation from her husband 10 days before her suicide. In the days after Micah took her own life, her family was joined by others in the community in creating justice for Micah in their search for answers. State and federal investigators have made clear that Micah's death was ruled a suicide. On November 1st, Court TV saw federal agents at John Paul's home removing items, while the FBI confirmed there was a part of an ongoing investigation. It would not offer any further detail, and John Paul has not been charged in connection with the raid. Apparently, Juju Bones is not particularly fond of John Paul Miller. She's saying in a quote, "that man." I don't know. I really don't know what to think. But it is. I will say that Micah Miller's death is tragic. It's tragic, and I hope at some point that if it comes to it, there is justice for Micah. And once again, if you need someone to talk to, you ask to call the Suicide and Crisis Lifeline by dialing 988, or you can text HOME to the crisis text line at 741-741. As always, as I said before, the Lifeline is available 24 hours a day, 7 days a week, in more than 150 languages. There's always someone to talk to. There's always someone that can help you. And yes, again, Micah Miller's death is very tragic. Please, don't do what. Let the last thought in your mind be that of taking your own life. Get help. Talk to somebody. Next up, Bryan Kohberger. His defense team has argued several motions to strike the death penalty, raising issues of fairness and cruelty. I'm gonna take you right to the video first, and then I'm gonna throw you in for a shock as to what the death penalty could look like.
But first, we want to begin in Idaho, where a major motions hearing is underway in the Idaho student murders. Here's Court TV anchor Michael Ayala with a look at the death penalty in Idaho.
Murder in the first degree, maximum penalties, life in prison, or the death penalty.
Bryan Kohberger could get the death penalty if he's convicted of first-degree murder in the stabbing deaths of 4 University of Idaho students.
Do you understand the maximum penalty? Yes.
The new law in Idaho could mean execution by firing squad if Kohberger is found guilty and sentenced to death.
We need to bring back the firing squad.
State Representative Bruce Skog co-sponsored the bill to make the firing squad a secondary method of execution in Idaho.
This firing squad is the backup method if we can't get the pentobarbital.
In recent years, pharmaceutical companies have filed lawsuits to prevent their drugs from being used in lethal injections. It's making it more difficult for states to carry out executions by lethal injection.
Pentobarbital does not have a long shelf life, so it's not as if we can stock up and hold on to it for years.
Idaho called off its scheduled execution of Gerald Pizzuto Jr. in December of 2022 after it couldn't obtain the necessary chemicals to put him to death. Pizzuto has been on death row for nearly 40 years after being convicted of murder in the deaths of an Idaho couple.
None of the firing squad executions, approximately 150 or so in recent recorded history, have been botched.
David Leroy is Idaho's former attorney general, now a defense attorney.
I think a good argument can be made that it's a humane method of execution. There is a cruelty factor, I think, of lingering between, as we have here in Idaho, 40 years and 7 years on death row, unknowing whether that sentence will be ultimately executed.
Skog says they look to Utah for direction. It's where the last firing squad execution took place.
There may be a panel of 5 or 6 persons with rifles, and one of them has a blank in it, so that they're not sure who had the blank.
There is no method of execution that will always work perfectly.
Robin Marr is the executive director of the Death Penalty Information Center, which studies the death penalty.
As long as we have human beings involved in that protocol, there are going to be opportunities for mistakes. And certainly there may be problems with the firing squad.
All right, let's bring in Court TV crime and justice correspondent Matt Johnson to get us caught up on everything happening so far. Always good to see you, Matt, especially here on set. Thank you for being in here. And we know a hearing is underway. Tell us, please, what are some of the biggest takeaways at this point?
It's been a long hearing, but it's so important as we inch closer to trial. Brian Kohberger's defense trying to get the death penalty off the table, even before his trial begins, set for summer of next year. Kohberger, accused of killing 4 University of Idaho college students 2 years ago this week. Today, his defense is arguing death by lethal injection or firing squad will be cruel and unusual punishment under the 8th and 14th Amendments of the U.S. Constitution. Take a listen.
Looking forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his execution is moving forward as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm looking at when I'm standing before you representing Mr. Kohberger and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston in our briefing, is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bethea'S decision. When you think about it coming off in light of the Bethea'S decision, and you look at what's happened since the Bethea'S decision, and we're going to talk about that a little bit later today when we're talking about evolving standards of decency, we'll talk about how things have changed in this country since then. But for these purposes, when you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall from the media at least, that the construction is actually underway. But I may be wrong about that.
That talks about understanding what a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist.
The judge right now taking all of this under advisement, but kind of signaling to what his judgment might be, saying that Kohberger, if he's convicted, The execution date would be decades away from now, possibly, and we don't even know what means of execution would be available in the state of Idaho, Judge Ashley, at that particular time, if and when his execution date is scheduled.
Yeah, really good legal arguments. I don't envy the judge.
Taylor is very good.
Yes, and the
fighting
judge.
for her client.
Ooh, but having to make this decision, Matt, I know he's taking that under advisement, as you mentioned. Now, there was a win for the defense. Tell us more about that.
It's pretty much the only victory and the decision that we've seen so far today. Kohberger was asked to attend all pretrial hearings in a suit and tie instead of a jumpsuit, and you can see right there, that's video from today. He won that motion. He was arguing through his attorney, saying that the media attention, it would impact a presumption of innocence and the right to a fair trial.
I did hear information from security and from Ada County Transport regarding security measures that would need to be taken had the court allowed Mr. Kohberger to appear in civilian clothes. The state did not object to Mr. Kohberger appearing with civilian clothes. The court has employed security measures and is comfortable in terms of the security and flight risk related to Mr. Kohberger with those measures, and therefore has granted the defense motion to allow him to appear in civilian clothes.
So for all the pretrial motions, and there's still going to be a lot of them ahead, he can appear in suit and tie. These hearings are still going on, and of course this is happening there in the Ada County Courthouse. This is a change of venue, but you recognize that courtroom, Judge Ashley, very well. I spent a lot of time there because this is the courthouse in the courtroom where Chad and Lori Daybell, they had their trial. That was also a change of venue there in Boise. And, it's also interesting to know as they make their arguments trying to get the death penalty off the case, that didn't really work for Chad Daybell.
Yeah, what a great point and great analogy. There are a lot of good legal arguments being made. Again, we just don't know what the judge is going to do. And suit and tie, not too surprised, state agreeing, but I agree with you. It's something the defense knows that they've won. Matt Johnson, thank you so much for being with us here on set. I want to welcome our guests for this hour, Circuit Deputy Solicitor Sampson and former homicide prosecutor Melba Pearson. Thank you, ladies, for being with me today. Let's first talk about that suit and tie. Matt's excellent reporting, and really the comment that this is a win for the defense, but the judge said the state didn't object. I think this day and age, pretty much any defendant that requests that, if there are no security concerns, is going to be able to be in regular clothes because they are presumed innocent. Melba, your thoughts?
Yeah, so good afternoon, Judge Ashley. It was great to be on with you. And I think that this was the correct ruling here because, number one, it is going to affect his presumption of innocence. He is presumed innocent at this juncture. The state has not presented all of their evidence. The jury has not deliberated, so he's presumed innocent. And as such, he should appear as someone who is, innocent, basically. So you put on a suit and tie, and then you're able to at least have that presentation where you feel a little better about yourself, where you're not sitting in a jail jumpsuit in orange or stripes, whatever it may be in that particular jurisdiction, and everyone's seeing you in that state and equating that with your guilt before any evidence has actually been presented. I think it's just a common decency thing, and I don't have an issue with it. If I was the prosecutor, I would agree with it as well.
Yeah, great points. I think it is common decency. Now let's turn to one of the harder arguments, April, and that is about the death penalty. And this is one of the few states where death by firing squad is an option. I know South Carolina is another one, but where do you stand on this whole argument and what the court might do with the death penalty or not?
And I think that's the problem that they're going to face, right, is we're talking about something that may or may not happen. And so I have seen, and I'm sure Melba has seen as well, where a judge will say, I am not going to rule. You have put the cart before the horse. There's no reason for us to be talking about this since we don't have a death sentence yet. So I think it is hard for a judge to make that decision. This judge can listen to all the arguments and say, well, you know what, I'm going to wait to see if we get to that point. Thanks for all of your hard work. I'm not going to rule. I've had that happen many times where a judge does that, just so that it's all on the record. But it's moot at this point until or unless a jury determines he needs to get death.
And I think, Melba, a presumption of innocence already be thinking about the death penalty when theoretically you are innocent of the crimes as charged. I think that's a lot for a defendant to carry.
Absolutely. And that's why the defense is trying to take this off the table, because if you take death off the table, it doesn't mean that if he's found guilty, he's going to get no punishment. It just means he would serve the rest of his natural life in prison, likely without the possibility of parole. And so, of course, there is a lot of debate around the death penalty and whether or not, we should still be doing that. That's a discussion for another day. But the reality is that is the law in the state of Idaho, and that is the maximum. But if the judge decides to take it off the table, or if the state decides that they're not going to pursue death penalty, that is an option. But the defendant has to carry the fact that, listen, he's rolling the dice big time. And this is not just, I might get 20 years in prison. This is, I might die, or I might serve the rest of my life in prison. So if there's any opportunity for plea negotiations, probably not the worst thing for him to be thinking about.
Yeah, absolutely.
So, Brian Kohlberger could possibly be looking at a firing squad in terms of the death penalty if he's convicted. And his attorneys are trying to take that off the table. Now, normally when it comes to the death penalty, I've only heard of the electric chair, I've heard of the gas chamber, I've heard of lethal injection. The only time I've heard of firing squad was in military cases, and this case is not of that nature. Would it be good for would this be a good thing for not only against Kohlberger, but the entire state of Idaho, if that happens to be the end result of his trial coming next year? That's something that remains to be seen and judged upon by the public. But for now, the judge is weighing this, and we should have a decision on it soon. But again, just imagine, Kohlberger's found guilty of 4 deaths, and he is sentenced to die by firing squad. Next up on the docket, I have this story and one more before I end it this evening. Three people are linked to the death of former One Direction singer Liam Payne. As he died after falling from the balcony of his hotel room in Buenos Aires, Argentina last month. Prosecutor Andres Madrea charged the 3 suspects, whose identities were not revealed, with crimes of abandonment of a person followed by death, and supplying and facilitating the use of narcotics. That's according to the prosecutor's office. Madrea also requested their arrest to Judge Laurel Bruniard, who ruled the 3 cannot leave the country. Liam Payne fell from his room's balcony on the 3rd floor of his hotel in the upscale neighborhood of Palermo in the Argentine capital. His autopsy said he died from multiple injuries and external bleeding. Prosecutors also said that Payne's toxicological exams showed that his body had traces of alcohol, cocaine, and a prescribed antidepressant in the moments before his death. Investigators said hours after Payne's death, he was by himself when he fell, but the prosecutor's office said Thursday that one of the people charged was often with the singer during his time in Buenos Aires. The second is a hotel staffer who allegedly gave Payne cocaine during his stay between October 13th and 16th. And the third is a drug dealer. The charges in Payne's case bear some resemblance to the U.S. cases stemming from the death of Friends star Matthew Perry a year ago. The actor's personal assistant and a longtime friend are among those charged with helping supply him with ketamine in the final months of his life, leading up to his overdose on the anesthetic. 3 young men were similarly charged in the opioid overdose death of Mac Miller in 2018. Local authorities gathered, among other pieces of evidence, Payne's cell phone records, material for forensics and testimonies. Yet they are yet to unlock the singer's personal computer, which is damaged, and other devices that were seized. Payne's autopsy showed his injuries were neither caused by self-harm nor by physical intervention of others. The document also said that he did not have the reflex of protecting himself from the fall, which suggests he might have been unconscious. Prosecutors in Argentina also ruled out the chances of Payne committing suicide. One Direction was one of the most successful boy bands of recent times, and it announced an indefinite hiatus in 2016. And Payne, like his former bandmates Zayn Malik, Harry Styles, Niall Horan, and Louis Tomlinson, pursued a solo career. The singer posted on his Snapchat account that he traveled to Argentina to a friend Horan's concert in Buenos Aires on October 2nd. He shared videos of himself dancing with his girlfriend, American influencer Kate Cassidy, and singing along in the stands. Cassidy had left Argentina after the show, but Payne stayed behind. Let's see. If you're referring to Kohlberger, no, that trial isn't until 2025. The thing is though, they're still trying to decide whether the death penalty will be on the table. And like I mentioned earlier, in case you missed it, if Kohlberger is found guilty, he could be sentenced to death by firing squad. Now, I want you to think of what that looks like. They may mention of the aesthetic being there's gonna be like five or six people with rifles. One of them will have a blank. The others will have live rounds. Now, the only time I've heard of death by firing squad is only in military cases. And then again, that might be accredited to how many military style movies I've seen. Court martials leading to death by firing squad. Could this be good for the state of Idaho? We'll have to wait and see when we get to that point. If we get to that point. But as far as this is way too similar to what had happened with Matthew Perry, like the article said. Only difference is this is this guy from One Direction fell out off his hotel balcony. Let's see how many guilty pleas we get out of this one. And let's see. Can I go ahead and say finally? Yeah, I think that was it. Let me see 1 second real quick because I may have missed something. Yes, I did. This is the last story I had for this week. Brad Simpson is charged with murder 1 month after his wife's disappearance. I am going to take you directly to the press conference that for all the charges that Brad Simpson is going to be charged with, including murder of his.
To Texas, where a press is just now underway in the case of the missing realtor Suzanne Simpson. Her husband, Brad Simpson's been charged with her alleged murder. Now, Brad was already in jail on gun and domestic violence charges related to his wife's disappearance. It's been a month now since the 51-year-old mother of 4 vanished near Trinity University in San Antonio. Authorities had not yet publicly revealed if Suzanne's body has been found, even after a multiple-day search of a local landfill last month. We're going to see what authorities have to tell us. Let's go in now for the start of today's press conference.
Good afternoon. Yesterday, the Almost Park Police Department, along with the Texas Rangers, have charged Brad Chandler Simpson with murder in the death of his wife, Suzanne Clark Simpson. We realize that this doesn't bring closure to Suzanne's family, but we hope it will allow them to enter the next phase of their grieving process with more clarity. We would like to thank Suzanne's family for their support and strength throughout this investigation. They are asking for respect of their privacy, especially for the minor children. There are also many agencies that have helped us in this investigation, and we offer them our sincerest gratitude. This thorough and tireless investigation has been conducted in efforts to find justice for Suzanne and her family. We want to recognize the Bexar County District Attorney Joe Gonzalez and his office for their advice and support with the complexities of this investigation. They now begin their work on the prosecution phase of this case. We also want a special thank you to the Department of Public Safety and the Texas Rangers who have worked tirelessly with us, and we thank them very much, along with all the support from the citizens that we've had. We'd like to thank the family and the public, and we want them to know that the search for Suzanne is still ongoing. The Simpson family provided us with this message today to read, so I'll introduce Mr. Bart Simpson.
Thank you, Chief. It's always important to do what is right, especially when it is most difficult. This situation is heartbreaking for us, but it brings some peace to our family, knowing that the authorities have gathered enough evidence to move forward with charges. This helps us come to terms with the reality that Suzanne is no longer with us, allowing us to continue the difficult process of grieving and focus on rebuilding our lives for the sake of the children and our extended family. We remain deeply appreciative of the Almost Park Police Department, the Texas Rangers, Texas DPS, and all assisting law enforcement agencies involved, and their dedication and determination to help us find Suzanne. We're also incredibly grateful for the support of our amazing, loving community, and for everyone who has reached out, supported us, and kept us in their prayers. It is our sincere hope and prayer that Brad will find the compassion and courage to end his family's suffering by cooperating with the authorities, his wife. Thank you very much.
Let me welcome our guests for this hour, criminal defense attorney Laura Uretzian and trial and family law attorney Michelle Thomas. And I really appreciate both of you being on with us today. Thank you so much. So really short and sweet, so to speak, letting the public know that, yes, it's true, the husband's been arrested for the murder of Suzanne Simpson, disappearing about a month ago. 4 kids, Texas realtor. First of all, let me just get your reaction, Laura, to the fact that they held the presser and share this information with the public.
Clearly, there's a lot of interest in the case. Otherwise, they wouldn't be holding this presser, and they're notifying the public. Maybe they're trying to put people's minds at ease. Maybe some of these people, it's a tight-knit community. Everybody knows each other. It must have been newsworthy enough for them to have a presser. So it just tells you that there's a lot of public interest and attention on this case.
Yeah, and a lot of family, I know, has been pushing. And we just heard from Bart Simpson, who said, Michelle, that it does bring the family some peace that they've moved forward with charges. But talk a little bit about victims. And this is the very beginning of the process, and it can go on for a very long time through a trial. So many things can happen, so many emotions. What do you think when you think of the victims of horrible crimes like this and they're going through the criminal process?
Yeah, good afternoon to you, Judge Ashley, and thanks for having me. You know, one of the things people don't realize is that when a crime is committed or someone is missing or killed, it's not just that one, the primary victim who's affected, but it's the entire family. It's the loved ones, it's the friends who care deeply for that person. And so while it may give them some comfort and release, we have to remember that, first of all, legally, this defendant is still innocent until proven guilty, but also this is just the beginning of a very long and hard journey. During the course of a trial, if this goes to trial, the family members are going to hear probably critical evidence and heartbreaking evidence about domestic violence and what their loved one may have endured. And so this is really just the beginning, and it's important to surround themselves with the proper support moving forward.
Right, Michelle, I didn't mean to interrupt you, but to surround themselves with that support is key. Let's go back in. I understand now they are hearing questions, providing answers. So let's go back to the press conference.
And continues. There's still information we ask. If the public knows anything, to please contact the Olmsted Park Police Department or the Texas Department of Public Safety. The Rangers have not stopped investigating this case, as it has been turned over to the District Attorney's Department, as Mr. Simpson has been charged with murder. So again, as we said before, the District Attorney starts their process in the prosecution phase, even though we are not stopping our search for Suzanne Clark Simpson.
Regarding the search, can you confirm that y'all are looking in the Bethea'S area?
That is one of the areas that the evidence had turned us to, and so we continue to search wherever the evidence comes up.
I know yesterday you got out Brad Simpson to question him. Is he cooperating now?
I don't have the answer, but I do know that they did bring him in and did charge him with murder, and I don't have any comments on any statements he may have made.
How is James Cotter playing into this? Did he?
Right now, I don't know. Like I said, I do know that it just led them to information or his involvement, but I don't have any information on his involvement that had anything to do with the murder.
Regarding the criminal investigation, a lot of the public are wondering how come somebody can be charged with murder when anybody isn't involved.
I think if you've seen investigations going on for a while, and the officers of law enforcement have gathered enough evidence in order to charge him with murder.
Do you know the decision behind sealing that arrest warrant?
I don't. I can only believe that there's still possible evidence in there that they're still trying to either obtain or discover.
What evidence do you guys have that you believe will help you guys convict Brad Simpson?
I don't have that information.
What kind of information did the public come forward with that would help your investigation?
I don't have that either. I do know that some people had reached out to the Olmsted Park PD and to the Rangers with some information, but I don't have any specific information from the public.
Yes, Brad Simpson talking about several children.
I got 2.
Is it going to be possible to make it?
His children?
I'm sorry?
Has Brad Simpson had contact with his children?
Not that I know of.
So I know we got several texts earlier this week asking for our emails, knowing that somebody was coming this Thursday, and Brad Simpson was charged with murder on Thursday. Did you guys know that you were going to charge him with murder when, we were getting a heads up that we were going to get information on you?
So I got that information just like everybody else. I think when they came up with enough evidence and information to take it to the DA's office, they did so this week, and that's why we're meeting today. Had it been earlier, then we probably would have had a press conference earlier.
Is there anything you can tell us about warrants and technology? How long does it normally take to get the information from a phone, or if you guys released that picture of Brad's truck to us, have you found anything on the GPS of that truck that helped?
I don't have any information on that.
Have you done any more searches into the landfill?
I do know that they continue to search. I can't give you the areas, but yes, they have searched other locations.
How confident are you all that you will find Suzanne's body?
I know that they're not going to stop searching, so.
So at this point, you're still accepting tips from the public for that search?
Yeah, and we had put out the phone number information to the Almost Park PD, so if anybody has any additional information, feel free to contact the department.
Is Brad Simpson asking for anything in exchange for cooperation?
I have no information on that.
So at this point of the investigation, so Joe Gonzalez was here, District Attorney's Officer Joe Gonzalez was here. So you're saying that the case is already in the hands of the DA, even when? So he's going to start?
They're going to start working on their part of the prosecution. So once he was charged with murder, that information is presented to the DA. So they begin their part of the investigation and the prosecution phase.
Even when there's an investigation going on, still?
As we still search for Suzanne and anything comes up, like we don't just stop the investigation once we hit the DA's office if any additional information comes up. But as of right now, he's been charged and the DA's taken their part in the process.
How rare is it to charge someone with a murder without having a body?
I wouldn't.
What does it take to do that?
Enough information for the DA to take it.
Are there nonprofits still involved in the search?
Not that I know of. Two more.
You need a name and title for the record?
I'm Sergeant Dion Cockrell, PI with the Texas Department of Public Safety. Last name Cockrell.
The first name?
Dion, D-E-O-N.
Why is it important that the Texas Rangers were brought in on this?
Well, I think it's such a big case, and the Almost Park PD asked for their assistance, and as a state agency, we assist all local and other agencies.
Last one, can you make a statement on the case?
Sorry?
What questions would law enforcement still like answering about this case?
What questions would I like? I think the most important thing is trying to find Ms. Clark.
Can you make a statement to what you said, Mr. Clinton is being charged with murder? I just need it.
Well, I can confirm that you did hear from the Almost Park Chief Villegas that Brad Simpson has been charged with murder and the case has been turned over to the DAs. Thank you.
Law enforcement very clear that law enforcement says they had enough information to take it to the district attorney, and that is why it resulted in charges against Brad Simpson, and he is charged with the murder of his wife. Her body has not been found at this time.
Okay, Bones. Well, it's good. It was great having you on in the chat. I hope to see you again soon. And as for Brad Simpson's case, it is still being investigated. It's still ongoing. The charges were filed on November 7, and yes, he is charged with the murder of his wife. But the body has, but again, as they said, the body has not been recovered. Okay. So now it is time for last rites. And I am going to bring up the photo of our condemned, if you will. Before I begin. There we go. Alright, there we are. And let me go ahead and prep this. And that's going to do it for this edition of Bethea'S Byte Reloaded. I want to thank everybody for coming in the chat. Juju Bones, Amy Crew, thank you so much for bouncing your opinions off on me and vice versa. And I want to thank all of you in the replay gang who plans on watching this replay. If you liked everything you saw that it came on here today, please be sure to drop a like, share, subscribe, and comment, whether it's in the comment section or in the community area. I would love to hear from you. It's the free way to support the channel. If you'd like to tip your host, I've got 3 ways for you to do it. You can do by PayPal. PayPal me /EKB316. Cash App $EKB316. Or Venmo EB the Last Outlaw. Nothing is obligated, but it's always appreciated. And if you just want to get in contact with me, I've got 6 ways to do it. You can hit me up here on Facebook at Bethea'S Byte Reloaded. On X, formerly known as Twitter, that's at EKB316, all caps. On YouTube, at Bethea'S Byte Reloaded. On Instagram, at EKB316, all lowercase. On TikTok, at King of Hearts 316 2021. Or you can email me. The address is kingofhearts316_09 at outlook.com. As always, I appreciate all the love and all the support I get from you. It's you guys that keep this thing running. This is your home for true crime news without the drama, where your opinions matter, where lively debates are encouraged, your voice is heard, and above all else, it's his justice served. Ladies and gentlemen, boys and girls, children of all ages, this is Bethea'S Byte, and it's reloaded. Ladies and gentlemen, again, thank you all so much for joining me here this evening. Let's try to do this again real soon. Until then, you all know what to do. Bite. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe to the channel, and drop me a comment on this video. Also, be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.